Alex here with part 70 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains detailed disclaimers and the underlying purpose of the series. Two things that I'd like to glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. I'd also like to take this opportunity to tell my viewers, if you are not getting all of the updates on the channel, like if you're only getting a few of them, it's most likely because you have subscribed but you have not clicked on the bell notification. If you click on that little bell notification button, that's a signal to YouTube that you don't just want to get the highlights, you want to get each and every single publication to the channel. So this is a video that I actually can go into my hindsight, or my my mindset in a lot of detail, and I know that's not something I can do with all of my docket videos. In fact, it's probably only something I can do with like maybe 1 in 7 or 8, because a lot of these things have blurred together. And there are a lot of filings that are stacked one on top of the other with very little time in between. But this one, I can remember a very distinct series of events. So I don't know, I mean, I'm sure most of you have been following this series in order. And if you can recall, my ex filed a motion to modify, well, more specifically to have child support reviewed with the intent to modify it downwards for my ex. And I filed a non-opposition. In other words, I had no intention to oppose the review of the child support. I did have a difference of opinion on the amount of the child support, but I didn't have a problem with the review. And I think it really caught my ex's attorney off guard. I think she was planning to characterize me as a vexatious litigant or a person who just makes her client have to go to court no matter what. And to see a non-opposition from me was a big sign that I was different from a lot of the other self-represented parties, and it was probably going to throw a monkey wrench into her plans, because not a lot of non-attorneys even know what a non-opposition is. And I do remember we were discussing what we thought the child support should be, and she and I couldn't come to an agreement. And the time limit was coming for me to have to figure out how to deal with it in court, because you have to respond to these motions within a certain amount of time. And so I was like, okay, fine. If you don't agree with me, I'm not going to just dig my heels in and fight you just for fun, just so I can look bad. I'm going to file this non-opposition to let the court know that I don't oppose child support being modified. I just don't agree with the amount. Anyway, after she saw the non-opposition, she approached me again, and apparently she talked to my ex and got her to agree to the amount that I was requesting. This is the thing, here's what the dispute was, and I'm not sure if I can even remember mentioning this in any of my previous videos. But my ex's attorney argued that because the formulas indicated that child support should be $70 some, to me, I should be getting paid $70 some a month. Because of that, I should just waive it. She wanted me to just waive child support. And I would have definitely done that if this was a low conflict case and we were both working for, working with each other. I was about to say working for each other. We were both working with each other on everything. We were able to resolve our differences without the court, etc. But that wasn't the case at all. We were having to return to court over and over again. My ex was finding every possible technicality that she could over and over again. And I thought to myself, if she had an attorney, or if the roles were flipped, would this attorney be arguing, hey, let's go ahead and just tell Alex that we're just going to waive child support. We're not going to make him pay $70 some a month. No, that's not what would happen. Her attorney would be contacting me and saying, you have to pay $70 and that's that. Too bad if you don't like it. That's the formula. This whole one-sided win at all costs mentality, it's just really disgusting. And especially for a non-attorney who doesn't understand how they try to manipulate you and psych you out. I think a lot of the victories that attorneys have over non-attorneys aren't even legal victories. They just know how to psychologically engage in, psychological warfare is what I meant to say. That was one part of it, but that wasn't really most of it. Most of it was the way she exploited my good faith. That was probably most of why I insisted that she needed to pay the $75 a month. I had been very nice to her in saying, we're trying to work out the child support amount, and since it looks like it's going to be a wash or it's going to be very low, why don't you just go ahead and hold on to those $300 a month until we sort this out? I was very nice to my ex. And her response was to drag things out. She basically said, oh, look, now he says I don't have to pay child support, so I'm just not going to pay, and I'm just going to never let this resolve. I'm just going to let this drag on and keep not paying. And her attorney went along with it. Just went along with it. She didn't tell her client, hey, you should be really happy that he's doing this for you. This is very gracious. Why don't we get this worked out? No. She was like, well, let's just take advantage of him. Let's just not pay for as long as we can. And then at the end of the road, let's just make it a wash anyway, so it's all justified. That was what really ticked me off. And for those reasons, I said, no, she's going to have to pay this amount. She's going to have to pay it retroactive. She's just going to have to do it. She's going to have to owe all of that money. And after I filed a non-opposition, I guess her attorney saw that I meant business. And so she approached me and said, okay, she got my ex to agree. She signed the stipulation and order, and just like that, the child support was resolved without a hearing, without an adversarial process at all. And I've talked about this before in my video, Delay Tactics. And I think I've talked about it in my video, Stipulations and Joint Petitions. But Delay Tactics covers it for sure. And that's just what works with them, is they don't come to an agreement because it's what's best. They don't come to an agreement because it's the right thing to do. They come to an agreement because you've cornered them, because you've twisted their arm. They come to an agreement because you forced them to come to an agreement. And I keep drilling that into my viewers because it's just the way it is with them. If you want to get a deal, if you want to settle, you have to go about it this way. You can't expect them to come to the bargaining table and care about you and want you to get an equal. No, they don't do any of that. You put their back to a wall with some kind of deadline. You pressure the crap out of them. I hate saying that, but that's what works. And then you get settlements. And it saves the court time. It saves you and your ex time as well. There's less stress. And it's unfortunate, well, at least for you. They actually like the conflict, so they don't like for it to come to an end. Anyway, I think at this point we should just go ahead and take a look at what we have filed. Here we have the stipulation and order. And as you can see in the upper left-hand corner, this was prepared by my ex's attorney. Oftentimes, a stipulation will be prepared by one of the attorneys, and the other attorney, or if you're unrepresented, the other person will review it and make sure that it's consistent with what they expected to agree to. And in this case, I've prepared some of these before. I just don't remember when. I'm sure it's going to come towards the end of my docket series. But in this case, at this time, my ex's attorney prepared the stipulation and order. So the summary paragraph is that both myself and my ex have stipulated to, and apparently without waiver of either of our stated positions and claims now pending. Oh, so she's talking about all of the, okay, so we have another motion pending that has to do with the education, and that has to do with the modification of the timeshare. So what she's saying is that this stipulation is just with respect to what's in it, and it has nothing to do with everything else that's pending before the court, which is smart for her to put in there, and I agree with that. Number one, the child support is modified pursuant to Rivero and Wright v. Osborne. If you want to know more about the Wright v. Osborne formula, please watch the video Child Support. And it looks like she has our income amounts, $682 for her, $553 for me, that they are offset to $148 a month. And the next assertion is that my ex pays medical benefits, which means she's entitled to a deviation in the amount of $75, which is going to drop her child support down to $73.91 per month. The issues outlined in the motion to modify child support have been fully and fairly resolved. And just like that, you've resolved something with a high conflict ex. It's an absolutely wonderful approach to getting an agreement from a high conflict ex. It works. Not all the time. I would wager about half the time, but it does work. Order. The court having considered, so as you can see, both myself and my ex have signed this. So both the parties are submitting the stipulation, but it needs to be approved by the court before it becomes an enforceable order. The court having considered terms and provisions of the foregoing stipulation and good cause appearing, and then he puts in the boilerplate language here about you can't abduct a child. I've talked about this a number of times. And he signs it. And just like that, this signature makes that agreement enforceable. And I can't stress this enough. Do not come to a verbal agreement with your don't come to a verbal agreement with even a low conflict ex. There's no reason to do it. If it involves your custody rights, you can just put together a stipulation. It is very little stress because you don't have to go to court. If you have an ex who is not wanting to sign a stipulation, they are trying to backstab you or in some way do something sneaky. If you guys come to an agreement and it's going to affect your legal custody rights or your physical custody rights or your child support, these are big deals. It doesn't take that much work to put together a 1 or 2 page stipulation and have it submitted to the court, because unlike an email or a text message agreement or a verbal agreement, this is an order, which means it's enforceable. I can understand people saying they don't want to go into the courtroom because it's stressful. But I can't understand people saying they don't want to put together a 2-page piece of paper with 3 signature lines, sign it, submit it, and get it signed by a judge. That is, it's just not at all hard or stressful to do this. It is hard and stressful to actually litigate. It is hard and stressful to go to a hearing or to go to trial. It is not stressful to put together a 2-page stipulation, get it signed by everyone, and submit it to the court. And now you have peace of mind that if any shenanigans get pulled, it's enforceable. Going into, and I would like to tell my viewers, is an email enforceable? No, it's not a court order. And is a contract enforceable? No. When it involves child custody or child support, it's not a court order. You can do contracts for all kinds of other things with, respect to business ideas and debts and all that. But when it comes to a child and who's going to get custody of the child and who's going to be paying for support of the child, that child is not a piece of property. To get that to become enforceable, the court has to be involved. The child, it's almost like treating children like slaves. When people are like, hey, let's sign this affidavit notarized, and now, no, that's not how it works. That child is not a possession. The court has to be involved when you're dealing with human beings. Anyway, moving on. Request for submission. This is what submits to the court the stipulation that we just signed. This was also prepared by my ex's attorney, as you can see in the upper left-hand corner. And if anyone's wondering how requests for submissions work, I'm tired of talking about it because I have a dedicated video that talks about nothing but this, and the title of that video is Request for Submission. Certificate of mailing indicating that my ex's attorney mailed this to me. Here we have an order for refund of appeal bond. This is what I was talking about in the last video. So the court has reviewed my application to release the bond. That's the first paragraph. And in the second paragraph, the court indicates that my notice of appeal was filed on December 21st and that I deposited a check with the clerk of the court in the amount of $500. And then the court goes on to paragraph 3 and states that the Supreme Court of Nevada affirmed the decision. My ex has not made a claim to the bond, and since she has not made a claim to the bond or filed an objection, he goes into the next paragraph and orders the clerk of the court to release the money to me. And they mailed it to me, and I got my $500 back. So yeah, people, it is annoying that you have to pay so much money to file an appeal, but you get some of it back. In fact, you get 2/3 of it back, at least in Nevada. Certificate of mailing. We have the court indicating that it mailed this document to my old address. Here we have an order setting hearing. So the court is now responding to our failed attempt to mediate. The court issued on June 3rd, 2011, an order addressing my motion to modify the timeshare schedule and have our son, go to a specific school. The court ordered that we were to attend mediation, and if mediation was not successful, the court was ordered a hearing to be set to address my motion. And in the next paragraph, the court asserts that because we have informed the court that mediation is not successful, a hearing will be set, and with the consent of the parties, it was set for July 21st, 2011 at 9:30 a.m. Here's another certificate of mailing indicating that the court mailed this document to myself and submitted the document electronically to my ex's attorney. Notice to set. Okay, so this was a notice to set that probably triggered that order. Let's see here. I've consulted with my ex's attorney in accordance with the court's order rescheduling the mediation appointment on June 9th, and I sent my ex an intent to consult with Department 11 of the 2nd Judicial District Court on setting a hearing. By the way, guys, I could talk a whole lot more about the notice to set. This is a 1-page or maybe a 2-page if you count the certificate. It's a very short document. It seems innocuous. It seems like, it doesn't matter. It's just a piece of paper that's just kind of like one of those business, you're handling a minor business, but it's not. It's very important to understand how the notice to set process works if you're in a jurisdiction that uses the notice to set. I heard, or I've noticed, that not very many do. So it's very likely that you will never have to learn how this works. But in Nevada, you do, especially if you're in the Second Judicial District Court. I shouldn't even say especially. For all I know, that's the only district that does this. So it may be just something that's just not very used. I mean, it's probably not even that common in Nevada. Anyway, at the very end of all of that other jibber jabber, I meant to tell you guys to please take a look at my video notice to set, because in that video I actually explain in detail how this procedure works. Here we have the notice of disclosure of secondary issues to resolve at the hearing, and I am indicating to the court that there are, I guess, a couple of issues that should be brought up. Issue number 1 is that she owes child support arrearages, and I'm requesting a judgment. And issue number 2 is that I want an order prohibiting us from bringing extra persons into his medical, dental, therapeutic, vision, and education appointments. I've talked about this problem before. I'm not going to go into it again. If you're watching the My Docket series in order, you'll know that my ex likes to bring in these third parties, and sometimes, not all the time, sometimes they add to the conflict. Sometimes they're just kind of just like an ornament, just like kind of dangling off a Christmas tree. They're just there and they don't do anything. So I don't know. By the way, this is not the right approach. This isn't a motion. This is just a notice. And I probably think that since we're going to a hearing anyway, I can just lump these things into what we're going to resolve in the hearing. I understand that I get that that I thought that as a non-attorney, but in hindsight, this is clearly wrong. The court can't deal with these requests at the upcoming hearing. It has to be briefed by a formal motion. And so I'm sure that the court is going to deny my request here, or the court's just going to not even address it, just going to ignore me. So just letting my viewers know, you can't do this, at least not in Nevada. If you have something that you want resolved at an upcoming hearing, you have to file a motion, and you have to hope that maybe the briefing process is completed before the hearing, and that if it is completed before the hearing, the court is willing to address it at that hearing and not set a second hearing. Notice of intent to object. Let's see here. So my ex's, what is this? I hereby notify my ex of my intent to provide evidence and a disclosure of witnesses as soon as possible, and an expectation to receive the same. Local rules of practice. So I'm citing a Rule 47 of the Second Judicial District Court that states when we intend to use documents that we need to provide to our opponent within a reasonable time of receipt, within 48 hours, what is it talking? Copies of documents. So this isn't even talking about witnesses. So I'm supposed to provide copies of documents that I intend to use at a hearing within 48 hours of the hearing, and I want my ex to do the same for me. I'm placing her on notice that I intend to object if she doesn't do so. This is, again, really silly. I shouldn't have filed this. It's a waste of everyone's time. It's a waste of the court's time to have to review this notice. Don't do what I just did here. If you want to place your ex on notice, you could do this by sending an email, and that would be good enough. If you later on have to object at the hearing, you could say, hey, I told them I was going to object. Here's an email I sent them, and they didn't listen, and now they violated the court rule. I think I was just filing things into the docket because it felt safer, and it felt like it was just more like in everyone's face that this was an issue, and that's just not an appropriate thing to do. It's they understand non-attorneys have no clue when they do random things like this, but over time you want to move past doing things that non-attorneys do. You don't want to look like all of the rest of them. You want to look different. Here we have the letter from the mediator, which is indicating to the court that we participated in mediation on July 7th and that no agreement was reached. So this isn't the letter I thought it was. There is a letter from a mediator. Maybe it was the mediator prior to this mediator. There's a letter from a mediator that specifically states that that the mediator doesn't believe that we're ever going to be able to mediate. And there's just another sentence added to the end of this sentence. And he's just trying to get the court to stop sending us to mediation. So if this was the previous mediator, that really tells me that the court has no clue what's going on and that I should have brought it to his attention. And I really do start to do this, guys. You're going to see motions that I file in the future where I talk about this. And I have a specific section dedicated to mediation, and I specifically tell the court, do not send us to mediation, please. And it works. The court stops sending us to mediation. So I'll show you guys how I did that, or how I went about doing that when I actually get to that point in the series. Clerk's certificate. So this is a certificate coming down from the Supreme Court of Nevada indicating to this court that the judgment was affirmed, and this is the decision on trying to delegate our parental duties between education and medical. Here is the affidavit of Yilmaz Ak, and I believe this is the principal. And this is the reason I wanted this to be under penalty of perjury, and I wanted it to be in bold that you face a fine or imprisonment if you lie, is because a lot of times people go about getting these letters from these people, principals, teachers, psychologists, etc., and they leave all these details out. And I think that it really makes the judges take the contents of it with a grain of salt. And if you're going to have them sign an affidavit, you should make it look as legal as possible. You should make it clear that what they're stating is under penalty of perjury. And the reason why is because people are already going to shoot a bunch of holes through these letters that are submitted. People are, judges, I should say attorneys. Attorneys are going to do that. Attorneys are going to complain that they can't cross-examine them. And one of the best ways that you can sort of set yourself apart from the other parents that do that is you can say, look, this isn't just a letter that I got from the principal. It's an affidavit. It's on legal paper. It says it's under penalty of perjury. It's in bold. It is very clear to this individual that this is a serious document and that he's not saying things just to be nice to me or just to tell me what I want to hear. He's saying things knowing that they're going to be used in a court of law. And I think that's the underline here. You want the person who is who is signing the affidavit to know that what they are putting in writing, what they're signing is going to be used in a court of law, because it just has that added sense of this person isn't being duped or suckered. This person isn't trying to placate you. This person is stating in all seriousness that certain things that are going on under penalty of perjury. Now, that doesn't mean you can just rely on this document in court. That's still hearsay, at least in Nevada. In other states, it's actually not. And in other states, you can use this. But in Nevada, you can watch my video Hearsay to learn a little bit more about those other states. Anyway, in Nevada, the rules of evidence do apply, and the opponent does have a right to cross-examine your witnesses at the actual evidentiary hearing. So the principal is stating that he's 39 years old, he's not mentally incompetent, he's never been convicted of a felony, he is not a party to the action, he's not related to me, he's not a friend or acquaintance of mine. This actually helps the court understand that this isn't just a guy who's buddies with me, who's going to prepare something just to help me out in court because he's my friend. He's a total and complete stranger, and he's a professional. Next sentence is that Coral Academy of Science was served a subpoena to appear in support, and the subpoena made it into his hands. So he's saying that he did get the subpoena. He's saying that Coral Academy of Science is shut down for the month of July, and a vast majority of staff are unavailable. He's saying that he's going to be out of town for July 21st. So he's saying he's not going to be available, and that he would otherwise have appeared to testify. Interesting that I mentioned this, because I don't think I knew this at the time. But in hindsight, looking back, you can use documents like this if you can show that the witness is unavailable to appear and testify. That is allowed. Interesting, because I think I kind of just accidentally helped myself out by getting that extra little sentence included into the affidavit there. He is the executive director of Coral Academy of Science. I thought he was a principal. He's probably both. He's probably both the executive director and the principal. For this reason, he believes he is the most knowledgeable representative concerning the elementary school. His duties as an executive director are as follows: to supervise teachers, instruction, discipline, and curriculum, to supervise the business and finance and facilities. Coral Academy of Science is an entity, is a K-12 school, and the statistics recorded by the state reflect this. Coral Academy of Science has two separate buildings. The elementary building, which is grades K through 5, and the middle and high school, which is grades 6 through 12, which is located at a different address. Coral Academy of Science is a charter school operating separately from Washoe County, and even though statistically recorded under Washoe County School District, along with conventional public schools, a child will not be admitted into Coral Academy by default. A parent must apply to enroll their child and participate in the random selection process. If a child is selected and enrolls, the child gains privileged status to continue his education at Coral Academy of Science. Having reviewed Coral Academy of Science's enrollment records, our son was entered into Coral Academy of Science and was enrolled by me. Coral Academy of Science Elementary School will commence classes on August 10th. None of the 6 recorded incidents of violence occurred in the elementary school. He has personal knowledge that there were no such incidents at the elementary school. He did due diligence in contacting the Dean of Academics, Cheryl Garlick, who advised him through an email communication that all 6 of the aforementioned incidents of violence occurred at the middle school or high school location. During the course of his position at Coral Academy of Science, there has not been a single incident of a child being abducted by an offender or any other person for that matter. To his knowledge, this has not occurred in the history of Coral Academy's existence. Coral Academy of Science is not having financial issues. Oh, I forgot that my ex mentioned this. She was trying to say that the school was having financial issues. The school operates more efficiently than a conventional public. Oh, I remember. I remember why she said this. She said this. I think she said. I'm like 95% sure that she said the school must be having financial issues because otherwise they wouldn't be charging all of the parents to go there. I'm pretty sure that's why she said that. But this is probably something that she mentioned in mediation, and I kind of just wanted to nip it on the bud. The last thing he's saying is that the Coral Academy of Science is one of the 10 schools in Washoe County that was rated with a high achieving status by the Nevada Reports of Accountability, and that only 14.5 elementary schools in the county have this exemplary rating. The last thing I want to mention is that I talked about an article from the Washington Post that I received, and I do want to mention, now that I'm reading this document, I actually remember how I got that article. He gave it to me. So he signed this affidavit, and he actually said, yeah, I don't know why she's saying we're such a bad school. Here's this article from the Washington Post. And I thanked him so much for that article because I actually used that in court, and the judge read it into the record. So it was a big deal. Oh, by the way, guys, the last affidavits that I filed in this series were I'm not going to say absolute trash, but for the most part useless. And you can see how much I've evolved in the affidavit drafting sort of area, because this affidavit contains nothing but admissible fact, statements of fact. It's everything that an affidavit should be. It's nothing about, this guy's a good father, this guy is a good person, I like him, nothing about that at all. It's, here are a list of facts that I am aware of, and here's who I am. And that's exactly what an affidavit should contain. Certificate of service by mail. I'm indicating to the court that I mailed this document to my ex's attorney. And then the affidavit pursuant to NRS 239B, which states to the court or to the clerk of the court that this document does not contain a social security number. Here's a list of exhibits from, I guess that's going to be an email with Yilmaz Ak. Let's take a look. Yes, okay, so he's telling me in an email, yes, these are from secondary. I'm not sure why she is so interested in secondary when her child is going to kindergarten, but have a great rest of the summer. Okay, so I'm telling him that she's reporting 6 incidents for the academic year. So even this guy thinks it's ridiculous that she's asserting this. And by the way, guys, a lot of people will make the mistake of taking an email like this and trying to use it as evidence. You can do that, especially with some of the states that have the exception. But it's weak. You really want to let this person know that I'm going to use your statements in a court of law. And that's what the affidavit says. It tells this person, everything that you're saying is not just in an email back and forth. This is something that will be used in court. And so be serious about what you're stating. Next document is the affidavit of Katrina Zmaila. I think I'm using just the fact that some of her kids are going to school. So she is swearing under penalty of perjury that she's 26, that she's not been declared mentally incompetent, that she's not been convicted of a felony, that she's going to be out of town July 21st in Las Vegas. Otherwise, she would have been available to testify. Okay, again, using that exception on accident. I highly doubt that at the time that I prepared this, I had any idea that there was a hearsay exception, that you can use a document like this when you can't actually get a person to court. Still, my ex's attorney could really push to have her appear by audio-visual communication. That's a thing, that's allowed. But for whatever reason, she didn't push for it. She currently resides at a specific address. This is ancient history. She met me at another address, which is ancient history. She doesn't even live in the state anymore. It's been a long time she's been gone. Otherwise, I would go ahead and redact this. This is really old information, guys. Her daughter attended the school. She enrolled her daughter in the school. Because she was enrolled, she did not have to risk the random selection process again. She just automatically moves on to the next grade. She actively participated in the school by attending each and every one of the field trips. She greatly enjoyed interacting with the parents. Her daughter has never been violently battered or assaulted at the school. She's excelled academically at the school. The teachers at the school who she's met have always appeared to be genuine. She will be attending the school as a first grader, and she will continue her daughter's education at the school. So this is just one friend that was going to, attend the school, which was one of the arguments that a lot of parents use to get their child into a specific school. A much better affidavit from her than the last one. The last one was mostly useless. Certificate of service by mail, just like with the other one, I'm indicating to the court that I mailed this document to my ex's attorney, and the affirmation under the law, which is indicating to the clerk of the court that this does not contain a social. Last document is the affidavit of service of the subpoena. This document is indicating to the clerk of the court that the subpoena was served upon school staff personally by a third person. Why did I have to do this with him, but I don't have to do this with my ex? The reason why is because of the court rules. In Nevada, the rules of civil procedure allow you to serve a document by mail, but only if it's in other paper and only if it is being served on your ex. Actually, I think you can do it with pleadings that are not the initial pleading too. But the rules of civil procedure that talk about subpoenas are different. If you're going to serve a subpoena on one of these third parties, that has to be done by somebody who is not you, and it has to be done personally, and it also has to include a check. So you can't just mail a subpoena like somebody at a school or like a teacher or a doctor and expect them to be validly served under the rules of civil procedure, because in Nevada, that's not good enough. That's why I had to get a process server to do this. And here is a subpoena. By the way, guys, I think I prepared this custom. Yeah, I did. I did prepare this custom. And as you can see, this is not asking nicely. This is not asking a member of the school to please come and appear in court or prepare an affidavit. This is commanding the person to appear under the law in Nevada. I talk a lot more about this approach in the video Witnesses. Please watch the video. I don't want to spend a lot of time on it because I already have a video dedicated to the topic. Also, please take a look at the video Subpoenas. And here are the instructions that go with every subpoena. You have to give them the instructions. If you do not do this, that's a violation of the law. And by the way, I don't even think this is under the rules of civil procedure. I think this is specifically under the statutes. We have two controlling areas of authority that govern how subpoenas are to be used and served, etc., etc. Part of it is in the Nevada Revised Statutes, which is the law enacted by the legislature, and part of it is in the rules of civil procedure, which is a bunch of rules enacted by the judiciary. Going into the aftermath, I prepared, it looks like 3 notices and 3 affidavits, total of 6 documents, but those were all free filings, so I incurred $0 in costs. My ex's attorney prepared 2 of the documents, the stipulation and the request for submission, and those are free filings, so she also incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, let's see here. Let's go over some of the easy documents first. I filed those 3 different notices, and I'm just going to attribute 1 minute to each of those because it's like pretty much stuff she already knows anyway. She's not going to care. So 3 minutes there. We got the letter from the mediator. It's short. Let's just call that a minute. So that's 4 minutes. We have the clerk's certificate. Again, she probably just didn't even look at it. Her staff probably took care of it. So that's another minute, say 5 minutes total so far with those 5 documents. Then we have the, 1, 2, 3, 4, 5. Yeah, that's 5 documents. Then we have the 3 affidavits I prepared. Those are going to take a little bit of thought. She's going to have to analyze those. Well, at least 2 of those. Still, they're not very... I'm going to go ahead and say 5 minutes for the one from Ms. Zmaila, which is going to take us to 10 minutes. And I'm going to say 10 minutes for the one from the executive director of Coral Academy. That one is much more important for her to actually analyze. So that's going to take us... So we're going to have 5 minutes there with Ms. Zamala's affidavit. That's a total of 10 with Mr. Yilmaz Ak. That's another 10, so that's a total of 20 minutes. Let's see here. We've got 2 orders from the court. One of them is about the bond. I'm just going to put that in a minute. Why does she care about the bond? So that's 21 minutes. Then we have the affidavit of service. Let's just put that at a minute. So we got 22 minutes. Then we've got the order setting the hearing. I'm going to round that up. I'm going to give that 3 minutes. So we're going to go to 25 minutes there. All she has to really do with that is mark her calendar for the hearing dates. So 25 minutes thus far. The request for submission, she would have had to prepare. She wouldn't just be reviewing one of the ones that I prepared, but it's a quick document. So I'm going to put that at 5 minutes, which is going to take her up to a total of 30 minutes. Then we've got the stipulation that she prepared. That's going to take a lot of effort with regards to communication back and forth. Let's go ahead and round us up to an hour. I do think it's not a very time-intensive document. I mean, there's no legal research really because we come to an agreement, but there is still the fact that she has to put effort into the stipulation and order, and the fact that she does have to communicate with her client. She's got to get her signature. I think it's a fair amount. I guess it could be something that's a lot longer, but let's just keep things conservative on the channel with regards to the attorney fees that my ex is paying. And rounding up the whole entire series of documents to a single hour does seem to make sense to me, especially with something that didn't require litigating, didn't require going to court really. At the rate of $250 an hour, that's going to come to $250 in attorney fees for my ex. And as with my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.